The appeal stands, the judgment is authored by Honorable my Lord Justice Vikram. He's requested me to read it. The appeal stands accordingly allowed. The impugned order is set aside. The writ petition is restored to its original number before the High Court. Further, the High Court to proceed and decide the writ petition in accordance with law in the light of the observations made above, after impeding the Axis Bank as a party respondent.
Chips had made it time bound as well. Time bound. Grateful to you.
This is again judgment authored by Honorable Justice Vikramnath. Accordingly, the appeal is allowed. The impugned order is set aside. The trial court will proceed in accordance with law to decide the suit on its own merits.
Much obliged.
Accordingly, we hereby acquit the appellant for the charge of the offence punishable under Section 8(2) of the Act of 2003 and Section 504 of the IPC. The impugned judgments are set aside to this extent. We however confirm his conviction for the offences punishable under Sections 323 and 352 IPC. Instead of making him to undergo the sentence immediately, the appellant shall be released on probation upon furnishing bonds to keep peace and good behavior before the jurisdictional trial court within a period of 3 months from today. The appeal is partly allowed in the aforesaid terms. Bonds renew डालना पड़ेगा। यहाँ लिख तो भी कर देंगे। करेक्शन करवा दीजिए बता बस। This is again, this is judgment authored by me. The appeals that succeed and are hereby allowed. The impugned judgment dated 11th October 2018, passed by the High Court, and the judgment of conviction and order of sentence dated 14th March 2014 and 19th March 2014, passed by the trial court, are hereby quashed and set aside. The appellants Putai and Dilip are acquitted of the charges. They are in custody and shall be released from prison forthwith, if not wanted in any other case.
Grateful.
Grateful to your lordships.
Just, my lord, your lordship is granted leave, my lord, on April. My lord, I'm just praying 14 days interim because of the marriage in family, my lord.
No,
I'm so sorry, my
you
lord.
want a particular date. When is the wedding?
3rd September, the marriage is there. Card is there, my lord, in the application. I'm just praying there is an application.
कोई क्या कभी लिखा नहीं नंबर से 4th date is a
My lord, the marriage is on 3rd September.
3 समय से पहले लगा ली we are giving you date. We are giving you date before the wedding.
The marriage is on 3rd September.
We have understood that. Otherwise, the matter is listed on 4th. We are informed, but we are saying it will be preponed. Some date.
Please, my lord, please.
Whereas your lordships have item 4 that your lordships are not going to be able to hear today.
It has to be now, as I understand, only Monday or Friday.
That's right. So we also speak if any.
After 30.
Any day after the 10th, Maharaj, when the constitution bench is over.
No, we'll have it this side.
No,
Mr.
that will
Sipal,
be,
what-
that will be a
One
long
minute,
day.
Mr. Bhattacharya, please just 1 minute. What we'll do is, at the earliest, Monday or Friday, I'll speak with my colleague and have a date fixed. We'll give it to you, Monday or Friday.
Fine.
It'll be at 2 p.m. or high on the board, whichever it is.
Well, let it be then at 2 o'clock, Maharaj, that's better because.
We are fully appreciative of that.
Give them.
Sorry?
Requesting after 8th, my lords.
No. Mr. If in rejoinder something is to be done. Exactly. Mr. Gopal Subramaniam is not available till 8th. So is Mr. Sipal not available because of that. We'll fix a date, you have to be there, please.
Lords have allowed a brief time for Sanjay joinder, my lords.
Certainly, we've told you. Some date would be given. Yes, please.
Please, my lord, I'm appearing for the petitioner. The FIR is at page 56. The date of arrest is 24th of November 2023. Incidentally, the original offence was under section 394 of the IPC. My lord, on the previous date, my lord, lordships has observed while issuing notice that the invocation of the MCOCA is not in accordance with the
See, at this stage, we are not inclined.
My lord, the invocation of the MCOCA itself is wrong in light of the, my lord, observations in the case of
We
Mahipal
will give
Singh.
you liberty should the trial not progress because charge sheet already stands filed charges.
Let the complainant be examined.
My lord, I will stay out of the jurisdiction of Pune city. My lord, the offences are punishable with maximum punishment of 10 years. I have undergone more than 1.5 years, my lord, in custody.
So,
My lord, and if
436
lordships
doesn't
have
come to
looked
your
at
aid
the
as
judgment of
present.
Mahipal Singh, my lord, it squarely applies to my
We have
case.
seen Mahipal Singh. We have seen Mahipal.
My lord, in fact, the affidavit in my lord, affidavit of the state also does not dispute the fact, my lord, that the principle, my lord, will apply to this case, my lord. My lord, if lordships have
No,
looked
please,
at,
Mahipal. There are two cases. Those don't say that Mahipal Singh will not apply.
my lord, it will apply. In fact, my lord, it is in my favor, my lord.
No, we are saying that the Mahipal ratio will not apply in your case. Is what we are saying. And
My lord,
at
may I
this stage-
please try to
at this
persuade, my
stage,
lord. Please have a look at the prior
Just
approval, my lord. which is at-
1 minute. At this stage, we are not inclined to interfere.
So,
The impugned order. However, we give liberty to the petitioner after the material witnesses are to move afresh after the material testimonies of material witnesses are examined.
Please, your lord. Malas, this is a case where Malas, a civil dispute has been Malas given the colors of criminal. Malas, the when the first time the anticipatory bail
Have you
was
seen the
granted-
counter? See, please, gentlemen,
Please, please.
when the matter is listed afresh, we pass orders, interim orders, keeping in mind various factors. Now we have seen the counter. Now, only because we have passed an interim order, that itself would not be a reason sufficient enough to continue with to make it absolute. You have to argue afresh. Please, have you seen the counter?
Please, my lord. Please.
Now, what is your answer to that?
All your checks bounced, you promised 4% interest monthly. That is on the face of it, an attempt to cheat people. Lure people into your trap.
My lord, basically what has happened is,
And High Court gave you opportunity,
Yes.
mind you. It is not that High Court didn't give you opportunity.
please, my lord.
The order was toned down. Initial order was of 70 lakhs,
I
then
am
it was 40
having
lakhs.
matrimonial dispute with my
That is
wife.
your,
my lord.
that is your problem.
My lord, kindly, my lord,
What does the complainant have to do with that?
my
Nothing.
lord, the complainant is the friend of my father-in-law.
Oh, that's right. That's
And my lord, all the cases are filed either by the father-in-law
Okay,
or
let's-
his friend.
okay,
My lord,
just-
this is the
just-
present complainant.
Okay, just 1 minute.
Please,
We
ma'am.
understand your liberties involved. Let's put it like this. What is the total amount due according to them? Though these are not recovery proceedings, let us tell you.
Please, my lord.
But the 1.26 crores,
No, my lord, he has deposited around 80 lakhs, my lord.
80.
80 lakhs with me, and I have already returned 40 lakhs, my lords. I have already given, they have admitted in their FIR.
28 lakhs.
And my lords, one more submission is, my lords.
Is there any other complaint against him of an investor fraud? Please tell us. If this is an isolated incident, then what he says is correct. Is it true? His wife has filed proceedings against him. No dispute. Any other complaint by any other investor?
Sir, I'll take instruction. I don't have instruction. But
My lords, in
counter, preferred.
my lords, in the FIR,
1
which my
minute,
lords,
one-
Let us see the counter. They have said something in the counter. How many cases against you?
my lords, one by wife, and my lords, 2 NI Act cases. My lords,
Okay.
these cases are also filed by the, my lords, same complainant.
Is 3 and 4 are the very same cases.
Same.
These are all 138 cases. Sir.
138 bouncing of
138
check
cases where he has
given by him.
given check.
Complainant.
Who
So rising out of the same
It's connected
transaction.
with the same transaction.
Same transaction. no?
That even, sir, the fact that it says legal note and 28 lakhs of interest.
And my lords, my lords may kindly appreciate, my lords, the default, my lords, I am agreeing. Lordships, I am agreeing that there is default, my lords, and
Okay.
I promise that I will pay this. Just may kindly also consider.
All
that-
right, all right.
Confirm. We are confirming the order.
Lordship,
We are allowing your application.
Much higher.
Lordship, so far we have issued 341A notice, Lordship. We
All right, he will come. He will come now.
let him join the investigation, Lordship.
That is a
That is part of the
23.
order. That is part of the order. He will come. He will.
Lordships, he is undergoing treatment in Mumbai, my lords,
अरे
for
भाई,
his spine
छोड़ तो दिया आपको और क्या
Please.
चाहिए?
For his counsel, my lords. I was reverting to his.
It's okay, it's okay.
Much obliged.
We had to argue with him.
Why not this
As a petitioner passed away, sir.
Petitioner has passed away. It has become infectious.
It's become infectious as the.
Yes, yes, we've seen it.
Petitioner, as per the affidavit filed by the respondent, it is evident that
Right on 19th March.
that the
March
appellant expired on death certificate is there on which date?
Page number 10, no, 19th March.
19th of March 25. As such, the present appeal stands abated.
Please, Your Lordships. The petitioner is the defendant number 1, Your Lordships. There were 2 issues, Your Lordships, one regarding will and another regarding the.
No, the issue was only with regard to the will.
Yes,
You
but
wanted to
unfortunately-
disown your other siblings, that's it.
Yes, Your Lordships, but the High Court, Your Lordships, doesn't touch the issue of will, Your Lordships.
No,
That's
but
one of
then the
issue of-
trial court has extensively dealt with it. Issue page 165.
Yes, Your Lordships. But the question is, Your Lordships, till
Thank you.
2000, I was contesting my father's litigation related to land reforms, Your Lordship.
That's all right. Thank you. Thank you.
Oblige, Your Lordship.
Have you understood the issue, no? Have we heard you enough? These are the two things which are important.
Grateful, Your Lordship. Always grateful.
Successful plaintiff is before this honorable.
No, who's the plaintiff? No, defendant is before us, a plaintiff.
Plaintiff is.
Yes. Sorry, plaintiff. Yes.
She lost.
No, you are the first wife or the second wife?
Second.
You are the second wife. So,
She is not the wife in there. So no
so
dispute.
therefore, you will have to show that the earlier marriage was not there. There was a divorce, and that you had also sought a divorce.
Yes, right.
Thank you. Have you understood it? Have we heard you? Good. Thank you. Did I condone?
Your Lordship, in 7, Your Lordships, as an abundant caution, mother had filed that application to be appointed as a guardian, so far as the execution of the developmental agreement is concerned.
ठीक है सर, yeah, you can text. ये तो arguable case है. There was a joint venture.
For petition where only the mother is the applicant with no respondent, Your Lordships. It was just for the purpose of seeking permission, which was filed before the district judge Darjeeling.
State को notice नहीं जाएगा.
State will have to be heard.
Yes, state will. I'll serve it.
So notice will have to
Please,
go to the
please.
state or
But
no?
you have not depleted the state as a
Party
party.
is not a party, Your Lordship.
So you have
The
to.
state, we will impede the state of West Bengal, Your Lordships.
आज ही कर लेते हैं. Just give the correct particulars. Correct is included as party respondent. Service state of West Bengal. Amended memo parties be filed within 2 weeks, within 1 week. Steps of service, thus the in addition, and standing council.
Permission to start something. Great. Deep obliged. There is some delay, Your Lordship.
Delay control.
May it please your lordships. Lordships, here the suit abates in 2018. Though an application is made by the plaintiff.
Don't be so technical about that.
No, so the plaintiff files an application for setting aside the abatement, but without that, without deciding on that, in 2022, he takes up my application under Order 7, Rule 11, on the day when the suit doesn't exist. I'll show your lordships. Please see page 123.
Technically, you're
Hyper-technical.
you are correct. You shouldn't have done that. Thank you.
Lordships, there is one more aspect. My application under Order 7, Rule 11 is on the ground there's now an arbitral award
We have seen that.
same parties on the same dispute. Now, how can
Not 7-11. Issue.
he is the one. I just seek 15 seconds, your lordships. I
It
won't
may take 15 minutes. How does it matter?
The thing required to be seen was whether there are tribal issues, which the court holds there are tribal issues.
Lordship, so 1 second. This is not the same as a case of res judicata, because here the parties have an agreement which is admitted. The agreement is on record. There is an arbitration clause.
Was the award on contest?
No, lordship. So he stopped
You
participating.
understand, because the managing that person who was contesting the proceedings passed away. The other directors would not have known about it.
No, lordships. Then they
Thank you.
Thank
May
you.
I just
Thank you, ma'am.
request?
30 seconds.
Request last.
15 seconds is over.
Lordships don't want to entertain this SLP. Let this issue be decided as a preliminary issue. That's
No,
all
no.
I'm
For
requesting.
the trial court to see.
Thank you.
Very well. Grateful, your lordships.
For the petitioner, Your Lordship, the core issue in this matter is that the High Court had decided the wife's mental capacity based on a short interaction with the parties without any medical evaluation, Your Lordship. The welfare of a 3-year-old child is at stake. So what happened was that an IA was filed before the family court seeking appointment of guardian to the respondent number 1, who is the wife of the petitioner, Your Lordship. Also, the parties are separated. Several transfer petitions had been filed by the respondent number 1, and she had been dragging the matter.
So she understands the consequences of her action. She is cognizant enough to file transfer petitions, and you say that she is not mentally fit. That's a self-contradictory stand you are taking.
Your Lordship, the respondent number 1 is suffering from schizophrenia,
That's
which
right.
is a very
It's a curable disease.
It is a curable
Yes,
disease,
so
Your
if,
Lordship,
if
but the
proper
process-
medication is given, there is no problem at all.
Your Lordship, let the family court decide the matter. Let the evidence, let the matter be posted to evidence. Let the High Court's consideration, High Court's view not be binding on the family.
What
court,
else the
Your
High
Lordship.
Court has directed? The High Court has directed the family court to continue with the matter and decide it.
Yes, Your Lordship, but
Yes.
there is a finding. Your Lordship may kindly peruse page number 3, Your Lordship, paragraph 3. Today, parties are present. We interacted with both of them. Absolutely, there is no mental elements as of now.
Not as of now.
Yes, Your Lordship.
That's it.
May I read further, Your Lordship? Which would incapacitate her to defend the case before the court, even if she is having illness or suffering from diseases that cannot be a reason to appoint a guardian when she is competent to defend herself. Hence, we direct the family court to note the above aspects based on an interaction with the parties and pass appropriate orders.
So the
So-
As of now,
Yes, Your Lordship.
court found, neither the trial court nor the High Court found your contentions to be legally sustainable law
But
or a fact of unsound.
But Your Lordship, that finding might be binding, will be taken
It's
critically
bound to
by
be,
the
bound to
family
be,
court.
because that will be, your allegations will be treated to be cruelty. You brand your wife to be mentally challenged or suffering from a mental illness without any material and support thereof.
Your Lordship,
Nothing,
I
nothing.
take
Yeah.
away the rights of the
Thank you.
rights of the mother of the child.
What's your good name?
Surya Gayatri.
You have argued very well. Thank you.
Yes, sir,
Thank
please.
you.
Well, the petitioner for lordship filed a suit in the year 2015 for declaration of his title and other reliefs.
Sir, look at the plain first, page 53.
Plain,
Huh.
the subsequent suitor, the present plate
Page
is page
53,
number-
because then how will you say
Page
that
number 23.
711 will lie?
Page number 23, he filed a written statement in my suit in the year 2016, questioning the very validity of my sale deed. Now in the 2023, my lord, he filed a suit for cancellation of my sale deed. Now that is clearly barred by limitation. It is beyond 3 years, my lord, and three binding judgments of this honorable court was cited. Your lordship may kindly see page 92, how the trial court has dealt with it. Not even reference to them, and a subsequent non-existent event was taken into account, and the limitation period was totally glossed over and saved it. They were that way High Court.
Sir, let the
7 years, man, 7 years after
let the
the.
suit proceed.
It is not a case of knowledge or something. Page 92, my lord. Page 92.
Participate in the suit and have it decided at the early.
Page 92, your lordship.
Have it adjudicated, sir.
Page 92.
We'll go
Yes.
through it, sir.
Para 19, ma'am. Here in the present case, after the content, as per the contents of the petitioner, defendant number 1, when he filed his suit in 32 of 2015 against plaintiff herein, others seeking declaration of ownership and possession of possession covered by the registered sale deed so and so. As the plaintiff got knowledge of the dispute, their ownership, possession of item number 1 to 3, present suit scheduled property, they must have filed the present nature of suit within 3 years from the date of their filing of the written statement. Written statement was filed in 2016. From the date of filing of written statement and suits, when they got knowledge about the registered sale deed of 2015 and not later. But as they filed the suit after prescribed of 3 years, the present suit is barred by law. 3 judgments were relied upon. Judgments of the honorable court.
All right, all right.
We issue notice.
Much obliged.
Thank you.
Stay of the further proceeding this also.
Further proceedings.
Much obliged. Very kind.
Adjournment letter. There's an adjournment letter.
We issue notice.
Why you file adjournment letters in accident claim cases?
Notice.
Item 12, Madam.
High Court has erroneously reversed the order, my lord. No cause is shown to the respondents.
Sorry, just one. Item 12, yes.
Kindly see the conduct of the respondents, my lord. Notice is, it's a registered agreement of sale. Notice is served, no reply. Summons is served, they did not appear. And execution proceedings are filed, they consistently appeared. After 1.5 years, they filed an CMIS. In CMIS, again, they continuously drag on the matter. They did not appear, they did not lead evidence. Trial and reason shown is
Losing this property, let them defend.
Notice.
kindly stay the proceedings. It is a remand.
Proceedings.
Grateful.
Item 13, there is a delay of 382 days in filing an ex parte, setting aside ex parte decree, my lord. My lord, petition number 3 was suffered from cancer, and this is a OP for return of gold ornaments, my lord. At least there should be heard on notice. My lord, there is a stay of further proceedings, my lord.
Okay. Stay of further proceedings.
Sure.
Stay. Delay is condoned. There is an adjournment letter.
1 lakh rupees have been deposited.
Personal difficulty.
Notice.
Notice.
Please, my lord.
But first of all, there's a delay of 423 days.
DP grant कर दीजिए.
Leave granted.
Notice for bail कर दीजिए.
Notice in bail.
Notice in.
I'm not seeking bail at the moment because let the record come, then I'll move for a fresh bail application.
Does not application. You file an application?
I have filed an application. My lord will
One
not
minute.
place any order
One
at the
minute.
moment.
1 minute. We'll say does not press the.
After record is received.
अच्छा.
ठीक है.
ठीक. इसमें ऐसे करें. Leave granted. Record be called for. Digital copies supplied to the council. फिर रहता है the application be listed immediately after the record is received.
Sorry, my lord,
I is listed after the record is received.
that's what I wanted. I'm so grateful.
Third person. एक मिनट देना, फाइल देना, प्लीज.
You should feel thankful that the state is not in appeal. What was the exception which applied to the case? Not even a finding of grave and sudden provocation, please.
There is a finding.
You are, no, it's only provocation, not grave and sudden provocation. Which exception applies? Read the finding, please, of the trial court, whereby the conviction has been converted to 304 part 2.
Paragraph, page 66.
Yes, read grave and sudden provocation. Where is it?
They do not know.
Thank you. You should feel happy.
No, I will be very happy if I am a good.
If the sentence of 4 years is maintained, that should be.
Permit me to argue the matter. It's a case for acquittal.
Sorry?
That's what I feel.
We'll issue notice. Why should we not enhance it? Just give it here.
An exemption to be discontinued.
Issue notice. No. Issue notice as to why we are so modern issuing notice. Why 302 be not? What are you saying, Mr. Nagmuthu?
No exception at all. No one takes.
We are issuing notice to you. It's a case of 302. We have been let off very lightly.
Retaliation.
You take a call. You argue. Please, we are ready to. We are here to listen to you. But we will not. We will not hesitate to discharge our duties. This is one such case.
Just look at the injuries man received. Simply because he died after 2 days, that's a different thing.
That's not the point.
It's a case of murder.
There, you ask me,
Would your lordship permit me 2 minutes? Would your lordship
Of course, but then that order of notice stands.
No.
Either or.
No, you will take a.
What hanging on my head?
Only, that is the risk you are taking. The risk you are taking. We are issuing notice as
No,
to
Mr.
why.
Raju, this is a pervert. There is no finding of grave and sudden provocation. The incident in temple had taken place. The accused went away, came back armed with the wooden logs only because 3 have been acquitted, giving them the benefit of doubt. You don't get any benefit because the head injury is attributed to you consistently. Anything more to argue?
Dismiss.
But I got some points.
The accused is directed to surrender positively on or before 1 hafte ke baad. Within 1 week surrender. Within 1 week surrender.
Very liberal consideration to the accused by the trial court, please.
At times, Murad,
Thank you, sir. Call the
Murad, I may be in a
Thank
position to
you.
convince your lordship.
Thank you. No, Mr. Nagmuthu, you are taking the risk now. We are telling you.
Murad, it is
No.
sword on my head.
No, yes, it is.
Lordship says
It
no.
is. There is no doubt about it.
Murad, if
Thank
that
you.
sword is removed, Murad,
No.
if that sword is removed from
Please
the
argue the.
Murad, I will.
Thank you.
Eyewitness corroboration by medical
next
evidence,
case.
nothing more. Thank
Call
you.
the next case.
17, there's a letter, my lords.
Adjournment.
This is a similar situation. High Court has reduced the sentence to 3 years.
And now,
My lords, there's a letter, my lords.
there's a letter.
17, it's a question petition. What reduction of sentence you are talking about? In which case you are standing? This is item 17.
Adjournment is paid for.
Keep your badge.
Yes, who's there?
Your Lordship.
Item 18, yes.
Yes, Your Lordship.
Yes.
Your Lordship, the entire dispute between the parties is in commercial in nature because petitioner and respondent, the main grievance of respondent, if we see the complaint also, is against the petitioner company that there are few checks which he says he is not liable to pay, and
Argue.
for the same, Your Lordship, we have already filed the complaint case before the, we have challenged it before the court, and we are in the,
What complaint you have filed?
against the dishonor of check, Your Lordship.
You have filed the complaint.
Yes, Your Lordship.
You are the complainant of this case, or you have filed against the complainant of this case?
Yes, Your Lordship.
For dishonor of check.
The respondent has issued a check which was dated 25th of March. And when I put the check in the bank, it got dishonored and it was returned on 30th. And after that, I have pursued the
Okay,
case
you tell us what is wrong with the order.
against, but petitioner,
What is wrong with the order? Please argue on that.
because the whole case is malicious in nature, and if we see the complaint also,
Please, what is wrong with the order is what we are asking you. You're unanswered. We are asking you to open up.
What are the grounds on which you are challenging? Does the complaint disclose an offense or not?
very vaguely, Your Lordship, against the petitioner, there is no allegation in the
You
complaint.
can argue this. That's what we are asking you to argue.
Against the petitioner, there is no specific allegation. All the
What's
allegations.
your name?
Rita Jha.
You argued very well. Notice.
Stay correct.
Stay.
Your Lordship.
Stay. You are working with whom? You are near. Yes, please.
Your Lordship. Said issued notice.
We had issued notice, yes.
Please have notice 105. So the counter.
Your quashing is allowed on the ground of lack of sanction, right? Just please answer the question. Read your petition. Where is the ground?
SLP, the 482 petition.
Yes, please.
So your Lordship is right. In the 482 petition, the ground
It
taken.
is not an utterance. The only ground is limitation. That's all.
There are two things.
Yes. Do you dispute this fact?
We have not taken that ground. We have not taken that ground. But my lords may just notice one aspect. Please have my lords section 105. Their entire case today appears to be that prior sanction is not required. My lords, 105 specifically makes it mandatory for prior sanction. 105 of the Factories Act.
Which was here.
Have you quoted it anywhere? Let us see the Factories, the Karnataka Factories Act or the Factories Act?
Pass on my iPad.
Prior sanctions.
It's there.
Sir, different way.
In fact, Manoj, may I just point out before?
Just hold on, one.
Yes. May I read that, Manoj?
Who filed the complaint?
The inspector.
All right. Now, what is the argument, please? Please read 105. You got the answer. We presume.
I have seen that. If the inspector files it, no sanction.
No sanction is required. That's it.
One more aspect I want to point out.
No more aspects. There is the only ground on which the High Court questions the proceedings.
That's right. But there is one more aspect. Manoj, please see the order by which process is issued. Would my lords for a minute have the order by which process is issued? It is directly contrary to two judgments of your lordships.
That was not in challenge before the High Court on the grounds which you are arguing, please.
I think that ground has been taken.
No.
That
What ground? What ground?
Well, the ground is that the order issuing two things. The order issuing summons and process under section 204 absolutely does not disclose, Manoj, any application of mine for the reason that in this case, our specific case was that this plant had never been handed over.
That is your defense, sir. You will have to take that defense before the trial court.
I had taken that there was a show cause, there was a show cause notice issued to me.
Why is the court required to see the defense of the accused at the stage of taking issuing process?
I am only saying, Manoj, that some application of mine to
yes,
Mr. Counsel.
Manoj,
Page 53 is the complaint. Correct? Page 53 is the complaint.
That's right.
By the inspector.
That's right.
Now, how do you come out of it?
The inspector has filed the complaint, except that they have not, Manoj, over here said anything about the inspector filing the complaint.
What more do you want page 82? Peruse the contents of the complaint and the documents produced with the complainant. Prima facie case is made out. That is what the language of cognizance is required to be. Thank you. Better not take any observations by this court. Your defenses will be prejudiced.
And I am saying this, my lords, is that in INOX, your lordships have said that some examination in
this is the examination, it's a public servant, no statement is required to be recorded. So this complaint's contents are there. The contents disclose a prima facie case. My state says that I have perused. That is more than enough.
It's just one aspect. I'll just point out.
We have heard the learned counsel for
I'm
parties.
number one, Manoj, my learned friend is just permit to place 2 points. 190, my lords, your lordships are consistently held, my lord. There ought to be a separate order, my lords, under 190, taking cognizance. And my lords, a separate order, my lords, under section 204, recording, my lords, the sufficient grounds, which is mandated, my lords, under the language of the statute.
All right.
There is absolutely no, my lords, order, pass, my lords, of order of cognizance. State away, my lords, the trial magistrate would pass an order.
It's a composite order, sir. First, the magistrate takes cognizance and then issues process. The order issuing process is separate. Need to update yourself on the order. Page 82.
You have heard learned counsel.
Thank you. Let the High Court decide all my objections.
Nothing.
One objection.
This was only on the sole objection. You will have many more stages. Mr. Devasa, you will have many more stages before that. Let the lawyers be enriched. There are 4 deaths. Gross negligence on part of the company owner.
In fact, the plant was never handed over to me, my lord.
That's your defense. You take the defense. You have a defense.
My lord, just permit me just 5 seconds, my lord. Insofar as, my lord, the manager is concerned, there is absolutely no allegation, my lords, in the entire complaint.
You want us to foreclose the defenses at this stage. All presumptions are provided in the act. We'll deal with everything and pass a reason order. Mr. Singhvi will be very happy.
Actually, not a correct observation because the complaint is quite detailed.
We have seen that. We have seen that.
And then it files.
The only thing we were bothered about is sanction. That is clear. That's why the High Court doesn't. The High Court doesn't even refer to the provision.
Complaint on top says that through the inspector, who is designated as an inspector.
We have heard learned counsel for the parties at length. Leave grant kar dena. In terms of the impugned order, the complaint preferred by the order passed by the Principal Civil Judge JMIC on the complaint preferred by the instant petitioner stands quashed and citizen. Full stop. The complaint under section 200 CRPC was preferred by the complainant, that is the state of Karnataka, under the provisions of the Factories Act 1948.
Complaint is filed by the respondent number 3,
Yes,
not the state, because the inspector is required.
Inspector.
The authorized.
No, state of Karnataka at the instance of. Complaint is by the state of Karnataka.
It has to be the inspector director, Manoj. It's the assistant director who's the authorized inspector under section 8 of the Factories Act.
No, the complaint page 53 reads like.
State of Karnataka at the instance of Party Magadam, assistant director of factories.
Yes.
And inspector appointed herself.
Lordship pleases. Manoj, it's page 53.
Let it be as per the complaint. That's what my lord is dictating.
That's what it is.
Please.
Yes, sir. The concerned court, the principal civil judge and JMFC Mudhol, passed an order dated 1st of October 2019 in the following terms. Page 81 -2 dash. Full stop. The respondent said challenge the same by way of a petition, criminal petition under section 482 CRPC, which stands allowed by the High Court in terms of the impugned order, which also is extracted as under pura extracted. We are the considered view that the High Court ought to have not applied its mind. We find that the order, to say the least, is cryptic. Is cryptic, is absolutely cryptic. The court has not even considered perused and considered the contents of the complaint as also the relevant statutory provisions. The complaint was preferred by the inspector. Complaint was preferred on behalf of the state by the inspector who was duly authorized. Section
105.
Section 105. Then section 105. Under of the Factories Act 1948 clearly stipulates the filing of the complaint by the inspector through the inspector without any prior sanction, previous sanction, written previous sanction of the authorized previous does not previous since the complaint is filed by the inspector himself, there was no requirement for any previous prior sanction in filing the same. In this way of the matter, we quash and set aside the impugned order dated so. We expedite the order passed by the CGM is restored. We direct the parties to fully cooperate during trial, the trial stroke inquiry. The parties are directed to appear before the trial court on dash. That's it.
Just make it clear that whatever defense.
All contentions are left open.
Devasa, and you forced us. You have an admission noted in the order. You admit civil liability to be satisfied by you. Thank you.
Thank you. Perhaps to that extent, the civil liability part is not correct.
It's an admission of guilt.
Very deeply obliged. Great.
Please, Bal.
My lord, it is the case of the respondents before the quashing court that all my shareholding, all my shares were duly transferred during the lifetime of my brother, late Shri Adilur Rahman. But the annual return of shareholding that was filed by the same respondents with the ROC as a part of statutory filing says otherwise. If I may be permitted to draw my lord's attention.
What was the forgery, please? As per your complaint, which was the document forged?
My lord.
First, let us understand the definition of forgery.
Yes, my lord will see my deposition.
Let us first understand the definition of forgery and then let us see your deposition. Which was the document forged as per your version?
At page 40, my lord will have.
Yes, please.
The share transfer certificate.
How do you say that this document is forged, please?
My lord, this is something that I'll have to prove. The burden is with me.
So, prima facie case of forgery, how do you establish that, please?
But at that point in time, the entire control of the company lied with my brother. And that is a consistent.
Irrespective thereof, gentlemen,
blank documents. I'll just
for establishing the fact that the document is forged, you will have to first satisfy the court that there was a false document within the meaning of section 463 IPC. Which is the false document as per you?
Cognizance was taken under 420, 468, 471.
Yes, so 468 and 471, there has to be an existence of forged document, which is, and what inducement was given to you to part with valuable security? Nothing.
And whose document was forged?
Precisely. My lord.
No, whose document was forged?
My share transfer form allegedly has been forged.
You admit your signatures.
I am not the same, my lord. I'm not admitting. This has been introduced by
You
the
said that you have said in your complaint that my signed documents were lying with them and they've used it. That's what your statement is.
Lord, we'll see the timing. 24 days from the demise of my brother.
Yes.
There's a magical transfer of the remaining shares of 8,400.
You should have gone to the civil court for establishing your rights.
My lord, I should be at least be in a position to contest all of this before.
We are asking you, what is the document for, please? Tell us.
During the lifetime of my brother, since he was in control of the company, I had given certain blank signed documents.
Gentlemen,
Those are the documents.
what is the forgery we are asking you again? Please tell us.
The forgery has to be.
Has to be is not sufficient, sir, gentlemen. Yes.
My understanding. I understand what is falling from my lords. And maybe that particular document was not before the learned magistrate at the time of seeking.
We are simply asking you, which is the document forged as per you in the complaint?
In the complaint?
Yes.
That particular document I could not point out.
All right, then forget about it. There can't be any prosecution without the document.
We'll also consider the annual return of shareholding completely reflects the deposition, the narrative that I put before the
was that a part
of that? Have you seen their counter? What they say about?
Yes, I've seen it. You obliged.
Lords, on item 21, the petitioners have already appeared before the trial court since last 22 years. They were directed to appear by the High Court by their order dated 1/7/2002 while granting them bail. Both the petitioners were
You are challenging the order of conviction.
Rejection of appeal.
yes.
Huh?
Yes, my lord.
Where were you for all these years?
थोड़ा सा CRPC देना. CRPC. Just 1 minute. पेज 44 से 68 तक देखिए.
As per my instructions, he's been convicted under Juvenile Justice.
Juvenile Justice Act.
He has been convicted.
He has been convicted as per my instructions.
Any appeal preferred? I have no idea.
Sorry?
Any appeal preferred? Anyhow, that judgment of his conviction is attained finality?
We are not aware of.
You are not aware. But are you not related to them?
We are not
Parents,
related to them.
Oh, what are you saying? Your parents of Manu?
We are not parents of Manu.
Then?
We are not even related to them.
Neighbors. The parents were also accused. What happened to them?
Neighbors were.
No, parents were not. There are three accused. One,
One.
the juvenile,
Nahi.
husband and wife.
Petitioners
What happened to
are-
them?
The petitioners are in bail right now, and for the last 22 years they have been appearing before the trial court.
No,
as per
that
the-
we are aware.
That we are aware.
and as per the order of this honorable.
All right, these are the neighbors. I'm sorry. I was under the impression that they are the parents.
We'll delay.
There's a systemic failure in this case. You've seen that? No. The High Court dismissed the appeal somewhere in 2014. They were appearing in the Sessions Court regularly. That's a system provided in many High Courts wherein after the order of suspension, the accused have to mark their presence in this concerned trial court regularly till the decision of the appeal. The decision of the appeal was never communicated to the trial court.
2024.
That's shocking.
We noticed that on 1st of July 2002, the High Court, while admitting the appeal preferred by the instant petitioners, had directed them to appear before while admitting the appeal and also passing order of bail in their favor. I had directed the petitioners to continue to appear before the trial court on such dates as may be fixed till the disposal of the appeal. The High Court decided the appeal in terms of the impugned order on 26th of June 2014. Record reveals that the petitioners continue to mark their presence for the trial court since the passing of the order of High Court. In fact, as the record reveals, from page 44 till from page 44-68 onwards, 44 to 68, since 21st of October, since 21st of October 2002, petitioners have been appearing regularly till 31st of December 2024. Full stop.
On which date they were?
On which date they were taken into custody. Full stop. We noticed that there has been a delay of we noticed that for more than 10 years, for nearly 10 years, the petitioners continue to appear before the trial court. Our attention is invited to the provisions of section 388 TRPs. Now, we have perused the provisions of section 388 answer.
Yeah, 388. Check it.
Check it.
Yeah.
Eighty-eight.
389 or something. 388, sending the copy of the High Court judgment. 388.
You peruse the provision of section 388, which are extracted as under. Quote kar dijiyega. Full stop. It appears that the copy of the judgment in terms of the said section was never sent to the trial court. Full stop. As such, under these circumstances, we are inclined to condone the delay of more than 3,835 days. Petitioners were not aware of the passing of the impugned judgment. Stop. Then record of the trial court. अभी इसमें लीव नहीं ग्रांट करते सर. Record में लेते हैं.
August.
आगे.
Is here, record, trial court recorder.
The record is. You've got the copies.
Yes, madam.
Then you can argue.
I can argue, ma'am.
You ready today?
Yes, yes.
Record है आपको बस.
Record soft copy में आया बस.
छत्तीसगढ़ का हिंदी में ही हुआ.
Translated भी है. I would have been happy if it was in Hindi. होगा हिंदी में भी होगा सर. मैं
आया रिकॉर्ड आया क्या?
रिकॉर्ड आया.
नहीं यहाँ पे नहीं. अगले हफ्ते रख लेते हैं.
हाँ.
Then we'll keep it next week.
Bail for ही.
You're on bail.
एक explanation just.
Direct no, we have the view that the registrar, no, let the Registrar General of the
Chhattisgarh
High Court of Chhattisgarh submit his report as to whether the certified copy of as to whether there was compliance of the provision of section 388 or not, and if not so, then the reasons thereof. Let the copy of this order be sent by the Registrar Judicial to the concerned High Court, to the Registrar General of the concerned High Court, latest by tomorrow. Then report be submitted within 2 weeks. Within 1 week. Within 1 week. 10 दिन के बाद list on dash.
I have just entered my appearance yesterday on behalf of the complainant, who's the respondent number 2 in this matter. May I only request for 2 weeks' time to file a reply along with any relevant documents?
Just 1 minute, please.
There is the petition of one of the accused has been allowed by this court. What more you are going to do? Is the case of the appellant any different from that of Dilip Bhai Sanghani?
My lords may permit me to file my reply. I'll place on record if there are.
Just for the sake of it, what reply is required in a criminal case? We just have to see the order, whether there is any difference in the allegations. Why drag it? What's the point?
How much time?
2 weeks' time, my lords.
2 weeks. But no further.
Grateful.
We are adjourning it for a reason. Are you aware of that reason? We want you to comply with that reason.
Complete your instructions.
Objection, Your Lordship. Item 23, Lordship, I filed my counter. I appear for respondent number 1 and 2 state. In case it is not on record, I'm also carrying copies, Lordship.
They are mother-in-law and brother-in-law only, na?
But Lordship, the issue is very short. They have sought quashing of the FIR.
This court has held down dozens of judgments that simply because charge sheet has been filed, that will not preclude the High Court to examine the matter on quashing whether the allegations make out a case or not.
Lordship, they have been granted a liberty to challenge that.
What the
charge
point
sheet.
they should have, that should have been permitted in the very existing 482. Why
Lordship,
increase the litigation in this manner?
In my counter affidavit, Lordship, I have filed the 161 statement. Prima facie case is made out.
That was for the High Court to see.
Worship, at no point of time complainant resided with us. At no point of time. Even sister-in-law has been exonerated in the charge sheet itself at page number, Worship, may I please? At page number 37. Charge sheet itself is saying that she has been exonerated because no.
We heard leave grant करके. We have the concern. The petitioner lays challenge to the impugned order, which reads as under, which is extracted as under. Extract कर दीजिएगा. In our considered view, the High Court, to say the least, the order is absolutely cryptic. The High Court ought to have assigned reasons. Peruse the assigned reasons after perusing the record before passing the order. In this view of the matter, we caution set aside the impugned order and remand the matter to the High Court for consideration afresh on merits in accordance with law. The petitioner shall be at liberty to take all pleas, including challenging the charge sheet for the High Court. Then all contentions are left open. Then parties are directed to appear before the trial court, the High Court on dash, give a date.
Very well, Lordship. Grateful.
Obliged, Lordship.
Please, Madam.
Lordship, in item 24, this is the matter against the acquittal by the victim.
Sorry?
The Lordship, this. Lordship, the SLP has been filed by the victim. The land trial court.
Now, but why now the affidavit says why wants to prosecute the?
I have filed the Lordship.
Sorry?
Victim girl late my
Victim
who has filed.
Correct. But they are married.
Married subsequently, that's what they, and under pressure. Who is going to accept that? Lordship, the marriage when they happened was around 17 years. There was a photos and there was the video the trial court has observed. Under the threat, the threat has been. Any video was recovered? Yes, your Lordship. The trial court has, your Lordship would see the paragraph of the land trial court, page number 80. Page number 80, your Lordship.
Leave grant. You have stated, huh?
Here on behalf of the respondent.
We are granting leave.
I'll just submit two things in this case.
Our affidavit says that, therefore, we today.
From the entire deposition, your Lordships, I feel that your Lordship would be of the view that it is a case where the prosecution has miserably failed and the appellate court has rightly acquitted not.
PW4, page 30, page 53, we have seen.
Your Lordships, unfortunately, I would again submit, Lord, that my learned friend is not properly instructed. He has not even annexed the entire deposition of PW4.
Have you filed your counter?
Lord, I'll file it, Lord. I've got the copy. PW4, Lord, he was recalled. And after that.
Cross-examination, not he, she.
Sorry.
The cross-examination was conducted subsequently.
Yes, cross-examination was conducted and that part is not omitted from being annexed before the court.
That is reproduced in the High Court's judgment, page 11.
Yes, your Lordship. Page 11, High Court's judgment.
All right, you file your counter then.
Then file your counter.
I'll do that.
Counter 4 weeks. 2 weeks, rejoined out 1 week.
Please, Lordship. If it may please Lordship, due to some personal difficulty of the counsel for the petitioner, I am only praying for adjournment, short adjournment, Lordship.
What do you say? He's in difficulties.
If he is in difficulty, let.
Okay. Next week.
Much obliged, Lordship. Please, my lords.
Your Lordship, in item 26, I appear for respondent 2 to 5. Yesterday I filed वकालत, Your Lordship. I need 2 weeks time to file. नहीं, मैं सर ये क्या है कि appearance नहीं थी इसलिए that's why I didn't spend time. I had some appearance much take time. That's
You want time? 2 weeks, 1 week.
I am appearing for the respondent estate, my lord.
Just 1 minute. Who's for the petitioner?
My lord,
Yes, sir.
my lord, in this matter, the PW3, my son is 11 years old, child witness.
In page 40, he has clearly identified you.
My lord, 11 years at the time of the evidence. And my lord, he totally denied the fact that he was present at the spot, my lord.
Either it will be acquittal or it will be.
My lord, at page number 49, he admitted that he was not present at the time of incident, my lord.
Yes, I want to save my father. This is what he says.
Page 43, it says.
Page 45, he says, I want to save my father. Earlier, he says everything what we prosecuted.
Everything. My lord, he has went to attend the ceremony, wedding ceremony, my lord. He was not present at the spot, my lord.
His son has said everything. And he also says, when in cross-examination, you put questions to him, so innocently he says, yes, I'm not trying to save my father. Therefore, now I'm saying in the cross-examination.
My lord, it is a.
Mother was also residing separately.
Exactly.
Beatings by him. They both were.
My lord,
in
it is
the-
prosecution case that it is a all of sudden fight between the father and the.
Your
The
presence
case
is
filed
there.
under section 304 part second.
What defense did you take?
What is your defense? Your own father.
What defense did you
What
take?
is your defense? What under which exception? 80 years old man. What was the grave and sudden provocation? What was the occasion for you to beat him? In the manner you have
My lord,
done?
it is case of weak defense.
Size wound over case of?
Weak defense, my lord.
Yes, then no
prosecution
defense.
must not
No
get
defense.
the benefit of the weak defense, my lord.
Repeated, Mr. Counsel, we are asking you.
My lord.
Tell us which exception your case falls in. Tell us.
My lord, I was not present at the.
Not present is
No, now you are saying not present.
Your son.
I have told my
Not
sister.
present.
Also told my sister, my
Sorry,
lord, that the
thank you.
incident has taken place, my lord.
Thank you. Thank you.
Wait, please, my lords. My lords, I have moved an application for substitution, my lord, but it requires my lord's indulgence, my lords. For the reason, my lords, the name of the deceased as per High Court's memo was Virender Dhirubhai Shah. And death certificate contains Virender Dheeraj Lal Shah.
So the valuation report has come or no?
Valuation has yet not come, my lords. My lord, the respondent number 1 died, so my lords gave me 2 weeks for filing substitution, my lords. I filed that, my lords.
Then
on 11th of August.
There is some discrepancy in the name.
My lord, the discrepancies for the name of the deceased, my lords. In High Court's memo, my lords, it's Dheeraj Bhai, and in death certificate it's Dheeraj Lal.
Dhirubhai.
Dhirubhai. And in death certificate is Dheeraj Lal. But my lords, respondents don't have objection, so if my lords,
substitution
with the consent, if can be allowed, my lords.
We'll allow it.
Yes, my lord.
Application is allowed. Now, what name should we give?
Lords, as per High Court.
As per the High Court or as per death certificate?
Death certificate, the father name of the deceased is Dheeraj Lal.
Dheeraj Lal.
Application allowed.
High Court's memo, it's Dheeraj Bhai.
Dheeraj Lal alias Dhirubhai kar dijiye.
Virender Dhirubhai Shah, correct?
Please, my lords, as per High Court.
Good stuff. We notice that the name of the respondent number
1, my lords.
1 as per the cause title is Virender Dhirubhai Shah, whereas the death certificate records the name to be Virender Dheeraj Lal Shah. it is not in dispute that the death certificate pertains to the very same person, that is respondent number one, first off, and that they are very same person. So then in this view of the matter, we have the view that in the cause title, that the cause title be read as Virendra Dhirubhai Shah alias Virendra Dheeraj Lal Shah. Amended memo of parties be filed. File amended memo of parties. Now what is to happen? In matter, what is to happen?
After that, my lords, perhaps they were to pay the rent, my lords. They were to disclose, my lords. And now, my lords, perhaps I received a call from my London.
Please don't put it there.
Perhaps for mediation, they were requesting. So if
You want mediation?
Say to the mediation of Bombay High Court.
No objection, my lords.
The parties are
No, by Supreme Court is better, no? Supreme Court mediation.
the parties are residing in Bombay.
Digitally or no, we know here. Supreme Court. वो पैसे वाला नहीं आएगा.
29, I appear for the state. By your lordship's last order, your lordship had
We have not
some
complied.
data that is being compiled. It will take some more time, your lordship, because
How much
the
more
data is
time?
huge.
How much more time?
Lordship will at least grant me 6 weeks, because the reason is there are some protection orders of the High Court for some employees. All those have to be found out from the records. It is taking some time, your lordship.
As already prayed for 4 weeks' time, further time is granted to the respondents to comply with the order dated
18/7/2020.
no further.
Grateful to you.
May I please request, my lord, in this matter, I seek 1 week time, only, the supplementary affidavit is ready, because they have filed some additional document in the, so we are just short affidavit, supplementary affidavit.
What do you say? How much time?
1 week.
1 week as prayed for is granted to the respondents to file additional supplementary affidavit. Would you like to respond to it? 2 weeks thereafter.
Your Lordship, in 30.1, 1 week's time may be granted to file the counter affidavit.
फिर उसमें अलग कर दीजिएगा, ये दोनों में कॉमन ऑर्डर करिएगा, पहले ऊपर फिर उसमें नीचे. 2 weeks time to counter 2 weeks is right.
Yes.
In this case, the question is of disability pension. The petitioner admittedly had 19% disability, and the disability pension was denied to him because of this. But my submission is that my case is now fully covered by the judgment of this honorable court.
Sukhwinder Singh?
In Sukhwinder Singh case.
What do you say, Mr.?
No, my lords, this case is not considered by Sukhwinder Singh because this case is only for those who goes out of service because of invalidity. Here the petitioner was discharged when willingness was asked from him to continue, but he said he placed his unwillingness certificate, my lord, and his, my lord, disablement is less than 20%, which is the benchmark, and that has been considered by the tribunal, my lord. If your lordship will see, the tribunal has considered this in detail. The impugned order, lordship will, 2 paragraphs I would like to say, my lord. First is paragraph 3 at page 3. May I, my lord? Paragraph 3.
The only thing is if the disability is aggravated because of his survey.
The benchmark is 20%. So unless a person, as per the rule,
Are we not to, let's see what Sukhvinder says, those are 14 ka 14.
That is annexed with our written submissions also, judgment. Sukhvinder Singh's judgment. We have annexed with our written submissions also.
That's what I said. Rather, my lord, on the contrary, my submission would be that this case is covered by other judgments of this honorable court on the same issue, my lords. On the identical issue, there are 2-3 judgments of this honorable court.
मैं देख रहा हूँ ट्रिब्यूनल ने इसको
बच्चन प्रसाद
extent of disability
Lord Bachchan Prasad, A.V. Damodaran and S.P. Rathod. These are the 3 judgments.
clearly yes sir
My lord,
less than 20% entitlement
he deals with this aspect of the matter, my lords. If your lordship in Bachchan Prasad, my lords,
Bachchan Prasad is the candidate who was having the disability less than 40%
lordships,
and he was awarded 50% disability pension on that.
that is, my lord, so far as that part is concerned, that is that it cannot be said that it was not aggravated due to his service in army, my lord. But then the courts, this honorable court said, but till it is in excess of 20%, he can't get
10% only. You see, there is a difference, Mr. Sanjay. Plantar fasciitis is a very serious condition because the very moment of the person concerned is compromised. So, and it is in both the legs. So that is a very serious condition. It is for the whole of the life. His movement is affected by this disease or the condition. Whatever, and it's clear that it is.
The report of the experts, that is the medical board, is not under challenge, my lord. He has never challenged it at any point of time, even before the tribunal. That is not under challenge.
So that's what we are saying.
Correct. And my lords have held that there is no reason to doubt the report of the medical board, my lords.
Let us see Sukhvinder Singh. Sukhvinder Singh says that even if it is below 20%, 50% disability pension has been allowed.
Only person who is invalidated out of service.
Sukhvinder was invalidated out of service.
The board, by the board. That is the distinction between the two. And these cases will not squarely considers this fact. If my lord will kindly have pleasure to see page 4 of this judgment.
How do you answer this, sir?
In this case also.
How would Sukhvinder apply on facts?
In this case also, he has been invalidated out of service.
In the petitioner also.
Petitioner also.
Let us see that. Where is that finding or where is that order? Communication.
Kindly see the medical report.
No. First, just show us that you were invalidated on account of your disability.
Paragraph
Sanjay, let him say.
Since my lord himself from my lord's where to show, the paragraph 3 of the impugned judgment.
Let him show.
Mr. Sanyal, if we can have it some other day, because that's the only thing you'll have to answer. We'll have it some other day.
Yes, this is a fact although.
No, but then in your list,
You are not able to lay hands on the document. We asked you the particular question.
we'll have it some other day. Or we'll do one thing, we'll just pass it over. We'll pass. No, what we'll do is just we'll have it after a week.
with proper preparation.
In a week, I have some problem.
No problem, any day.
After 10th of September.
After 10th September. No difficulty. But you will have to, or if you are ready today, when we come back, you tell us. You have to only answer this.
Where is the invalidation order?
We'll just rise, we'll come back after 5 minutes. We'll come back after 5 minutes, you just let us know. We'll also adjourn the matter should the need be. We appreciate. Yeah, give us 5 minutes.
Lordship.
Yes, sir.
Lordship may see for a moment page 90, my lord.
Page
90.
90.
Opinion of the medical board.
No, we want to know whether you were.
Expertise ready in a minute, Lordship. I will come to that. Give me a minute only, or I would seek my lord's accommodation. Lordship,
Where is the communication which says that you have been discharged because of this disability?
Yes.
Huh?
87.
87. See that.
Annexure A1.
Yes.
At the top, if your lordship will see medical board proceedings, there are two
The
things.
release in medical category. Low medical.
low medical.
Cut and release is there. So he is being released, not invalidated up. And that too because he did not opt for willingness, did not gave his willingness to continue in service because the medical report says
In a different post, probably in a, all right.
Yes. Comes page 95. It's clearly not there. Page 95.
Your release can because
and he's getting the regular pension.
He is released from service in low medical category. Page 95 says so.
Page 95, if your lordship
Then
will have pleasure.
page 110 is the order.
Fit for all types of employment civil. Page 95.
I will invite my lord's attention to page 110 and 111.
First, please see 87, where invalidment is scored out. And where is the unwillingness to continue, sir? Mr. Sanjay? Yes, and 95 says fit for all types employment in civil. And where is the option given and his refusal?
Page 41 in our counter affidavit.
There must be some document to support that. Page 41. All right, all right.
Page 41.
Page 41 at page 42. Start from certificate for consideration of retention in service discharge from service permanent low medical category JCOs. Next page, page 42 minutes.
Now, where does he say that I am not willing?
Unwilling to continue in service.
Individual is not recommended for retention service being unwilling.
Counter affidavit. Page 3, the counter affidavit says.
Sorry, sir.
Lordship, page
it pains us to say we wanted to help you because you have served us. You served the nation. And because of you, we have, comfortable sound sleep. But what do we do?
Should they count? In their counter affidavit, they say that there was no post available.
DFC. Page 3. What do you say? Your counter itself says that there is no available in the shelter, non-availability of shelter appointment. Yes, yes, yes.
Page 3.1.
What do you say, Mr. Sanjay? What after that? How was it to continue? You yourself admit non-availability of sheltered appointment. No, sir. Please, there's a huge difference. If you say, what option does he have? You are the employer. You are the almighty for him. You yourself say that there is no post available. What do you say to this? Having been placed in permanent low medical category and non-availability of sheltered appointment, what was he to do? Nothing in his hands. We will what? This is on affidavit, Mr. Sanjay. No, sir. We are not going to permit you to.
But then, as percentage is concerned,
and then
that is
37.
So that will be as per Sukhvinder Singh. We will treat him to be invalidation and 50% as per Sukhvinder Singh.
Therefore, I was showing to my lord that judgment.
Lordship would also see page 37.
Judgment
30 of what?
Of their counter.
37. Let us see what you want to point out.
This is their letter.
Yes.
And page 37 top. Cause of discharge.
Medically unfit for further service. What more do you want, sir? To squarely cover him with Sukhvinder Singh.
Not covered by Sukhvinder Singh. Why? I kindly see me not Bachan.
What do you say to this, sir? Medically unfit for further service. Your own document.
So far as medically unfit.
What was he to do thereafter? Discharged for what reason? That you don't have anything to offer him.
Medical category, and then, but the benefit, his disability is less than 19%.
Where was he to serve, sir, please? That's what we are saying. Sukhvinder Singh, it was 6 to 10% only.
I'll just take the distinction, but kindly see this judgment. Yes,
What was he to do thereafter? Please tell us. You treat him, you want to say that he should have been, he should have taken the option of sheltered service, sheltered post.
That is one of the aspects.
Then what is he to do?
If a person,
What is the option available to the employee in such a situation where your board says unfit to continue?
but with disability less than 20%. Disability is less than 20%.
You are kicking him out. It's a fact. Disability is because of service.
But first he showed his unwillingness. If you
No, sir, sorry, please don't. We are not allowing you to argue that now. Having seen your affidavit.
see that
Yes.
he is making his unwillingness.
All right, sir. Thank you.
It is
Unwillingness is dated, my lords.
All right. Thank you.
Or your lordship just grant me one opportunity.
No. Absolutely no.
I'll check from the record.
Yeah, we are dealing with the army man
Not the record
who has served the country for 10 good years.
mentioned there.
no, by mistake, your affidavit can't be by mistake.
So far as that aspect is concerned.
That is corroborated by this document, please.
Mr. Sanjay,
Lordships.
if of your own you want to give it, there is no difficulty. You see, two options. We have given you our name.
Lordships.
We are allowing the petition. If you feel that it is going to be a wrong precedent, then of your own you may do it. But as we look at it from your affidavit and the documents filed by you,
Then your lordship may, I'll seek instruction on this issue, my lord, whether they can do it themselves. Lordship may.
tomorrow,
Come back tomorrow.
Thursday,
Monday, my lords.
Tuesday,
I have some difficulty, my lords. I have to-
Thursday, sir.
Well, Monday.
Thursday.
Monday, no.
That is not after.
This combination
After
would be,
10th, my lord.
this
After
combination.
10th September.
Today or Thursday, sir. We have given you
Thursday,
your mind.
talking about this Thursday.
Yes, of
Tomorrow.
course.
Or you want next Thursday also, there is no difficulty.
Yeah.
Then digitally you can be there, no difficulty.
Then
You will,
day after
Day after
Okay.
tomorrow. Yes.
better you do it of your own.
Very grateful. Very grateful.
Do it of your own, that's the end of the matter.
Much better. The graceful
Very grateful.
decision on part of the employer.
They are the defense personnel,
my lord, I
Don't
can
treat them shabbily.
see, my lord. I can see, my lord. And
Get it, in fact, get it done.
Then
Officer, please get it done.
It's the office report is showing that service is complete.
No, service is not complete perhaps.
Some
No, complete.
no one has entered application.
So none is entered appearance.
We brought
Leave grant,
fresh service. Fresh service.
leave granted, fresh service.
I'm asking for the respondent, your lordships, as it fell from your lordships on second time to take necessary instruction by the department if they can be regularized. So the department is considering your lordships will take another 2 weeks time, so it can be posted by 2 weeks. We'll come back with the clear instruction because it has some financial implications as well.
Okay.
Any date after 2 weeks, your lordship.
As prayed for, 2 weeks' time is granted to file additional affidavit by the respondents.
Lordship, this is an instruction, not additional affidavit regarding the regularization.
You instructions you may give, we are saying file affidavit because after all government has to take a decision. No?
That's correct.
Better that you file it and file an affidavit.
Very well.
List on that. List on. Good. इसको हमने ना उनके साथ सुना.
Grateful.
34 was I apply for the petitioner.
Sorry.
For the petitioner, my lords, in this, my lords.
Yes.
My lords, the possession of the shop has been taken away a week back, my lords.
So then it has become infructuous.
My lords, but please have page 51.
You are a tenant in any case.
I'm a tenant, my lords. But both the lower courts are in my favor.
We have seen that.
In fact, my lords, I had mentioned the matter also, my lords, but please have 51 for a moment.
51, what do you want to say?
Now, on all counts, my lords, the High Court in a revision, my lords, can't reappreciate the whole thing, my lords.
No, that's
all. That's academic now.
It is, the position of the demise premise is already since taken over by the respondent landlord. In this, we have the matter, the present petition of infructuous, disposed of.
Deeply obliged.
The adjournment letter. What? 35, there's a letter.
This is the legal aid matter. And although your lordship granted me the opportunity to file rejoinder, I could not connect with the appellant. He's the poor workman, and it's on the legal aspect that whether the alleged compromise is mandatorily to be registered under Section 28 and 29 of Employee Compensation Act.
Section 29 says
it's mandatory, your lordship. There is judgment of this honorable court that this is mandatory.
That legal loophole is there. But it is ascertained by all the courts below that money has been paid. The fact remains that money has been paid.
No,
legal expenses and compensations amount.
Your lordship.
But the legal loophole is that there is non-compliance of this.
Labor Commissioner specifically held that the money has not been paid and passed the claim in my favor. That averment on the part of my learned friend is wrong. That all the
whatever, but you have to get, if the amount is incorrect, then at least it has to be by a rejoinder. Leave grant. Rejoinder we filed within 8 weeks. Hearing expedited.
I leave.
37, I'm seeking it not passed on, my lord.
My lords, I'm requesting for a pass over. The arguing counsel is on his legs in another court.
Okay. Is service complete? Okay.
So now it shall.
Pass over.
What's up?
Item 38.
Please, your lordship.
Adjournment letter.
This matter, my lords, there I am told that two of the respondents are dead, my lords. Number 194. The registered post which I sent it, my lords, returned back with the endorsement that they are dead. I have to take step, my lords, for respond number 194, my lord. And Puttananjay Gowda and Arse Gowda. They are the landowners.
As per the office report, they were, my learned friend said they were served on 14/5/2022.
So service is incomplete as per the tracking report.
Yes, ma'am.
Said that just the notice affidavit was
Incomplete on 1, 2, 3, 4.
Earlier, I had
5.
made an affidavit, my lords. Thereafter, lordship said that they are unrepresented. You sir again. I sent them by post, my lords. The two of them has been returned back, my lords, with the endorsement that they are dead.
Yeah, dead. Then you have to take steps in bringing your lords on record.
Let steps or fresh steps or service of unserved respondents be taken within 1 week. Also, we are informed that now it appears that which of the respondent?
Number 194, my lord.
Respondent number 1 and 4 नाम आ जाएगा. Are no more dead कर दीजिएगा. If that were so, then steps of substitution be taken by the petitioner within 4 weeks.
Great.
Lordship, service is still complete. Lordship had asked the SSP to be served through him. The report has not come. I was praying if Lordship would permit us, in addition to that, maybe we can issue a publication and some time can be given.
Let the report come.
As Lordship pleases.
Let the report come. SSP report is awaited, no?
Yes, Lordship. It's in the office report also, Lordship. Last paragraph of the office.
The office report, respondent could not be served. that fresh steps for service be taken. Respondent be served again through, we'll say through SSP only.
Yes, please, Lordship.
SSP.
Some returnable date, Lordship.
Some date will be taken.
And Lordship, there are interim orders they need to continue.
Interim to continue.
We are grateful, Lordship. And the last hearing, Lordship said, asked me to appear. There's also an amicus appointed.
That's all right. What do you say?
My lords, I've prepared a short chart, computation chart, if I may pass that along.
Please. You're the insurer.
Please, my lords.
Liability is fastened on you.
Yes, to be paid, they've come up for enhancement, so liability is not disputed. So that's just the enhancement they're looking for.
ठीक है sir.
My lords, I'm also sharing the minimum wages chart for the year 2010.
हमारे हिसाब से 1170 बनता था, इन्होंने 1145. We'll allow it.
So far, Your Lordship, this is subject to verification. I looked it up on internet. It ranges from 100 rupees to 130 rupees per day. But my learning friend is
2010, it's all right. In today's date.
My lords, there's a small observation in the impugned order, my lords.
Audi?
In the impugned order, my lords, at page number 4, my lords.
So we are enhancing it as per the chart.
What observation?
My lords, that interest would not be carried out for the period of 17 to 19.
2 years because they were not pursuing, Your Lordship. They were not arguing and taking up the matter.
No, that's not fair.
No.
Not fair.
My lords,
Can't
may
be.
kindly have.
Order, the interest has to apply from the date of filing of the claim.
Unless there is delay in filing the appeal, that's a different matter.
My lords, may kindly record that.
We'll do that.
I'm so grateful.
We have seen 6% interest.
I'm so grateful.
From the date of filing of the claim.
Grateful.
41, Your Lordship, there's a letter. 40, there is a letter, sir. 41.
41 तो हो गया ना sir.
41 हो गया.
41 में adjournment.
There's a letter, Your Lordships.
41, there is a letter.
There's a letter. I'm seeking some time to file my rejoinder.
Yes. इसमें लिख दीजिएगा no further opportunity.
I'm seeking a Passover, my lords.
Passover. Okay, Passover, but there are not very many Passovers. So we are telling you, we'll
Come back in 5-7 minutes, more, not more.
So item 43 is that equivalent BSc polymer can, Lordship's own judgment is there in Shifana.
Yes.
Justice Mehta's judgment.
Yes.
I put it in the
yes.
compilation. So our short submission of PSC is BSc polymer chemistry cannot be equated to the prescribed qualification.
Yes, sir.
May I take your lordship to that judgment itself, Lord?
My lord is the author of the judgment. So you.
Yes, Lord. That's why I'm saying. In that case, it was specifically stated that there was no equivalency given by the university. A letter was given. So this court said that it cannot be accepted. Here is a case where, my lord, the equivalency was declared by the university.
No.
Yes, your lordship, kindly see page 92, my lord. That's why I'll stick on to that point, my lord. My friend has stopped with that. I'll stick on to that point.
Chemistry is not chemistry, sir.
No, my lord. Your lordship, may kindly see this case. Equivalency is declared by the very same university. Kindly see, my lord, page 92.
92 of what, your counter?
No, my lord. Your lordship will get the convenience compilation is given by the other side. Your lordship, kindly come to page 4 of that.
Yes.
Yes, my lord, that's a judgment.
Shifana.
Paragraph 13.
Yes.
Paragraph 13. This court in so and so held that judicial review can either expand the ambit of the prescribed qualification or decide the equivalence of the prescribed qualifications with any other given qualification.
Yes.
Therefore, the equivalence of a qualification is a matter that can be determined in the exercise of the power of the judicial review. Whether a particular qualification should or should not be regarded as equivalent is a matter for the state as the required recruiting authority to determine. In indication so and so judgment of this court, while relying upon the earlier judgment in so and so, held that equivalence is a technical academic matter, it cannot be implied or assumed. Any decision of the academic body on the university relating to equivalence should be by specific order or resolution duly published. The fervent plea advised on behalf of the appellant that the University of Calicut has issued a certificate dated 10/10/2011 verifying that BSc Polymer Chemistry course of the said university is recognized as equivalent to its BSc Chemistry course is also not enabled in the light of the observation in Unication CV.
in view of the settled principles of law flowing from the above, we are of the firm view that the appellant herein was not qualified for the post advertised white notification dated so and so. Here is a case where that the equivalency was not declared by the university. Here is a case where the university declared it. The case put forth by the other side, BSc, before the tribunal as well as the High Court was that, my lord, that a university cannot declare an equivalency of the degree passed by the same university.
Yes, naturally. Naturally.
This Lords may kindly see the judgment of the High Court, wherein at paragraph at page 11, Lord, could your Lordship kindly come?
Even in Shefana, come to para 15, please.
Yes, I'll come to that.
Come to para 15.
Yes.
That takes care of the argument which you are advancing regarding the university having issued the equivalency certificate.
Lord, that's a case where, Lord, not by the university.
Yes, university, please.
The fervent plea advanced on behalf of the appellant that the University of Calicut had issued a certificate verifying that BSc Polychemistry course of the St. University recognized its equivalent to its BSc Chemistry course is also not tenable in the light of the observation by this court in Unification CV.
Yes.
But the previous two paragraphs not there.
Yes, there should be a specific order or resolution of the board duly published. Where is the resolution in your case?
That question was considered by the Your Lordship may kindly see.
Where is the resolution, sir? Simple as that.
That is exhibit P14 before the tribunal, my lord. It is not before they have not produced it. Give me time, I'll produce. I file a counter. Your Lordship will file.
You have not file a counter as yet. No, you will file a counter.
We have filed a
Then
filed a counter.
There is a statement. Where is the statement in your counter that there was a resolution by the university? Let us see.
Yes.
Let's see. Or where is the observation in the High Court's order? Or the tribunal
that's what I'm saying, Lord.
No, in fact, neither the tribunal nor the High Court say.
Yes, both are there, Lord. Both are there. Your Lordship, first I take to the tribunal's order. Your Lordship kindly come to the tribunal.
See your counter. Let's see in your counter where do you say that?
In Shifana, it was the same university. Kannur University. Same notification.
Same notification.
Then it's okay, sir. Then it's okay.
This question was considered by this court earlier. This question was considered by this court earlier, and all others were given. And now they say that judgment cannot be relied upon because it was a case specific for that purpose only.
Yes.
But here is a case where the very
Let us see the High Court judgment that there was a resolution by the university.
Lord. This was considered, my lord.
Let's see.
Your Lord may kindly see at Lord, page 11. Your Lord may kindly see.
Yes, please.
Page 10 last. Page 10 last. The judgment. So a contention was taken by read it, my lord. Contention was taken by the Public Service Commission's reply statement that recognition by the university will apply only to the BA degree and not to the degree in subject. The said point was not rightly canvassed before us by the Learned Counsel for the Public Service Commission. Then it was held by the tribunal.
There is the observation that there is a resolution by the university, sir.
Yes, my lord. That's why.
Oh, this is simply jumping to conclusions.
Yes, your lord.
This is jumping.
The previous paragraph also.
Yes, we have seen that.
Yes.
What is the date of the resolution?
Resolution, my lord.
Yes.
That is not. Could your lordship?
That's not.
Be time to produce that, my lord. I produce that because.
Read it from the CAT order, please.
Discuss CAT order.
Read it from the CAT order. So that's what we are saying.
Yes.
That if there is no discussion, there is no question of you being granted.
Please kindly come to, my lord, the CAT order, my lord.
Yes, it's a 2-page order.
57.
57.
It was considered. OIS 613 was paragraph 6. It was considered.
Yes.
Then,
let us see. Where is
57? Your lordship will get at paragraph 6. The consideration of 613 by 2012.
Mr. Counsel, please tell us where is the reference to any university resolution, please.
Yes, my lord. Your lordship may kindly see. Come to 59, my lord. Come to 59.
Yes.
Where it is stated that we think that the meaning of the words prescribed the qualifications cannot be curtailed or restricted in that manner. It will partake within its
all proceeding on assumptions. There is no document, there is no resolution.
Yep, which is P14, my lord. P14 was the one considered by the tribunal. That is why Annex A40, your lordship will get at page 58. 58, your lordship will get. Likewise, the second sentence. Likewise, when a degree in chemistry is prescribed, a degree in polymer chemistry also being a degree in chemistry is acceptable.
Where is
Apart
that?
from that, in this
where is
case,
the document? Are you having the document? It's Nair. Are you then?
Apart from that, a lot of document.
We'll have it day after.
Yeah, tomorrow. Come back with this document.
Yes, it is mentioned there, page 58.
Let us see the document, sir. Let us see the document.
If the resolution is there, he's out of court.
Yes,
If the resolution is not there, you are out of court.
Simple as that. Just considered, that's why I submitted.
List
Have a
on
pledge.
Thursday.
Thursday.
These matter batteries. Your Lordships, in this matter, we have not filed a counter and there's a reason for that. Your Lordships.
It was a limited notice only.
Yes, yes.
My lord, it is regarding the
visit. Question your Lordships of any visitation rights being granted and show your Lordships why.
Why?
These WhatsApp chats were in fact shown to the learned trial court as also to your Lordships the just speak for themselves.
What was the content?
Learned trial court. The learned trial court was of the opinion that these should not be brought on record
Yes,
and
yes,
to protect the dignity of the respondent and the children. If your Lordships has the first page, I won't read, I can't read these out, your Lordships, in open court. If your Lordships has the fifth block that starts with Tujhe. Thereafter, your Lordships, the last 5 chats on the first page. And then the next page. Your Lordship.
You really want us to comment on this?
Let me seek instructions.
This is nothing, no question. We'll dismiss it with the heavy cost.
The learned trial court also
This
after
is ridiculous. This kind of guy asking for custody of children, visitation right with the daughters. How much is he paying by way of maintenance? Tell us.
52 lakhs is the alimony that has been given.
Full
52
and final
lakhs.
alimony, your Lordships,
Full and final.
given towards the wife and the children. That also your Lordships was given at the time when they had agreed that they were originally going to give mutual consent. That also came to be contested. If your Lordship sees the reason why they have come, that is also in the WhatsApp chats. He threatens us saying that I am going to take you all the way up to the Supreme Court and then I will get you to the streets. If your Lordship the children were examined by your Lordships, the learned trial court, and thereafter the High Court also, although that was not part of the order. The learned trial courts records the statement of the children. The Honorable Bench of the High Court also records speaks to the children, but is not recorded as part of the order.
This guy doesn't deserve to be called a human being even. Such people, my goodness. What's the language he's using with his own wife? This is really reprehensible. Perverted mind, absolutely perverted mind.
The trial court gave him despite this, the trial court gave him the opportunity to interact with the children once a month.
Need not even be brought near him. They need not even be brought near him.
Petitioner lays challenge to the impugned order dated 14th of October 2024, whereby his request for grant of visitation rights stands dismissed, rejected. First of the High Court has only affirmed the order passed by the trial court. To similar effect. We notice that the High Court has interacted with the children.
Your Lordship, the learned trial court had interacted.
High
High Court had interacted, but it is not part of the order, in fairness.
No, para 7. Okay.
Your Lordships. They had deposed before the
Deposed,
trial court.
okay. That the trial court had interacted with the children who are though minor but of
17 years and 13 years.
Intelligible age. Aged 16. Today aged
17 and 13
then
years.
aged 16 and 12 years. First up. The High Court, rightly so, did not place on record the WhatsApp chat exchanged, WhatsApp messages sent by the petitioner to the respondent wife, to the respondent, former wife. We have respondent, mother of the children. We have perused the chat, copy whereof was supplied to us, and returned the same to the learned counsel. It is not in dispute that the messages were in fact sent by the petitioner to the mother of the children. In having accounted for the entire circumstances, attending circumstances, we have the considered view that the present petition only merits dismissal with heavy costs, which we quantify to be rupees 2 lakh. The cost shall be recovered as arrears of land and
shall deposit filling which it shall be equal as.
2 lakhs, full stop. The petitioner shall deposit the बच्चों के नाम कर देते हैं.
ठीक है, बिल्कुल.
Your lordship may consider giving it to the children because it's full and final alimony.
The said cost shall be paid, shall be kept in the, shall be deposited in the name of an FDR of the said amount shall be prepared by the petitioner in the name of the children to be encashed on their attaining majority. So the the mother would be the nominee. Full stop.
In case it is not deposited.
Full stop. In case the amount is not deposited by the petitioner, the same shall be recovered as arrears of land rent.
It can be the responsibility of the family court.
The family court shall ensure compliance of the order. Gentlemen, you have to show yourself to a psychiatrist. That's it.
I was not aware.
You have to, you have to show yourself. You, not you. We are not saying you.
Really sad situation.
1 week accommodation is sought at a moment. 1 week.
Adjournment.
Sorry, where is it?
Ejectment.
Before going into the merits, I want to.
Item 45,
adjournment.
46, sir.
Yes, my lord. Before going into the merit, I want to inform your lordship that the symbolic judicial possession has been handed over to the landlord. But my lord, my entire articles are still inside of the premises. So
go to the trial court, move an application for
I am seeking to take them out. Your lordship may consider kindly giving me some time to vacate that premises because
you yourself say that it has been vacated.
My lord, all the keys have been given. The entire article, because there was a existing office, my lord, that was operating, and the entire material, everything is there. So I am only requesting, my lord, let the some time may be given so that I can vacate the premises by returning.
It is also notice that symbolic possession of the premises already stands handed over to the respondent landlord. In this way of the matter, we find no reason to it.
Kindly request only for that. Only some time, 1 month or 2
next
months.
Next case.
Lordships, in item 47, notice is served, your lordship, service is complete.
Service is complete?
Yes, your lordships.
What is there?
Your lordships, this is a SLP at the instance of the insurance company. Compensation has been enhanced, your lordships.
No, but then rightly so.
issue involved, your lordships, is that the claimant, your lordships, despite having continued in his service, loss of income and future prospects has been given to him.
His currency notice case. Public servant. He's a government servant.
He's bank employee.
Bank employee. So
Cashier.
Is the loss of income there? Vacation in last year.
For bank development, income. The report, respondent stands served on 7th of July 25. None has entered appearance. In the interest of justice, we adjourn the matter. Full stop.
He has effected the complete recovery has been made. The amount has been paid.
No, your lordships, that's what I was requesting.
There is a stay.
There is no stay, your lordships.
Stay conditions, sir.
The challenge is on the ground that there was no future loss. There couldn't have been any future loss. Correct?
Loss of income.
Loss of income.
Because the respondent continues.
Or the respondent was gainfully employed with the bank. In this way of the matter, we stay the operation of separately. We notice that the High Court has enhanced the compensation by almost 10 lakhs. In this way of the matter, we stay the operation of the entity.
Grateful, deeply.
Please, my lords, I am requesting for adjournment. My arguing counsel is still standing.
It is Monday, Friday को देती है.
Difference.
Issue is, my lords, we are actually a temple, my lords, whether it's an industry or not, my lords. Now at High Court, my lords, by the impugned order at page 7 has relied on a Bombay High Court judgment, my lords. They were actually doing a commercial activity, my lords. I'll just show that judgment also. We are now High Court, my lords, by the impugned order at page 7. In fact, page 6, my lords, has para 13. My lords have that?
Yes.
I'll just read para 13. This court is not impressed by the submission advanced by learned counsel for the petition merely
But
because
your negotiations have failed, na?
They have not taken place yet. As of
Sorry? No, it was suggested. It was suggested that we'll set aside the order, you don't claim your back wages, and no objection if respondent.
No, my lords. No, my lords, not to my. No, my lords.
I don't know why I have written here. Petitioner says no objection in your respondent joining as areas of appointment already sent. And notice on industry order to be set
If it
aside.
happens, last
No
time my
back wages
colleague
to-
was there, he said.
Okay, maybe I may have scribbled my other notes. Okay.
So, my lord, this is the Bombay High Court. They were actually doing commercial activity. Now, what they are saying that we give it for marriage and all, my lords, we actually have a guest house also, but there are Jain Munis stay there. It's a Jain temple. In some rooms, our stuff keeps there, and in Jain Munis are there on a very nominal rate, my lord. So, it's not that we are doing a commercial activity. So, this judgment which what the High Court has relied on the impugned order, Bombay High Court is not applicable. This is, my lords, would see at page 95, para 7.
Only thing is, how can it be an industry?
Industry, yes, that's the short part. I'll just show two judgments of this court, my lords. Bangalore Water Supply. Please have a look at page para 110.
If there is a proof of the building.
I'm only asking you, how do these charitable institutions, or for that matter, these temples, dharamshala, they become industry?
Actually, 90% of the temple premises is being occupied by this dharamshala, having 110 rooms, your lordship.
So,
how
is it for pilgrims, etc.? They are being used.
Even online also.
It's okay. So that's right. We understand. That's for pilgrims,
Very nominal
not for
rate.
commercial activity.
They are taking 1400 rupees for the booking this.
So,
How does it become an industry mainly because
Claiming that they are a charitable institution.
that is for maintenance, etc. 1400 is nothing nowadays. Electricity charges.
your bar association is industry. No, we are only asking.
Please have a look at two judgments of this court, my lord.
Commercial activities are being carried on.
Leave grant, interim order, interim order stay, hearing expedited. इसको लगाइएगा कोई अक्टूबर में करा दें.
Very well managed.
Stay order confirm कर देना.
Interim confirm.
Grateful managed.
An important issue, but you see.
My lord said,
Thank you.